First of all, welcome everybody to the first in our series of webinars dealing with the difficulties and dilemmas that businesses will face in these difficult times. The aim of today's webinar is to look at how businesses can potentially reduce their most significant costs, i.e. their salary costs. So basically what I'm going to cover today is an update insofar as I can on furloughing and the job retention scheme, to deal quickly but not in detail with issues relating to those employers who sadly will need redundancies, and then to look at the options that employers possibly have to vary terms and conditions of their employees. Really going to have a quick look at the furlough scheme. So everybody is probably familiar with the details of the scheme in terms of the current government scheme, which enables employers to cover 80% of the normal salary cost of their employees to employees that are furloughed, subject to the maximum cap contribution of 2,500 a month of salary. So really anybody who earns 37,000 and above, the maximum contribution to salary or the maximum grant available per employee is 2,500. And obviously there's a contribution to employers' national insurance contributions up to that level, and also to the auto-enrolment minimum pension contribution costs up to that level also. Currently, as at today's date, there are 8.4 million employees on furlough, with 1 million employers participating in the scheme. What we know at present, 2020, chance the current scheme will be extended until at least the end of October 2020. Sadly, even though the government promised that we would have details of the scheme by the end of May, it hasn't yet provided details to enable me to be truly topical. So we can only cover about what we currently know. So we don't know the details of the scheme, other than it will continue in its current form until the 31st of July 2020. The government announced that the scheme will continue to entitle employees to 80% of their salary for employees who are furloughed at the end of October. My understanding is that employees would have to be furloughed in July in order to be able to continue in the scheme from the 1st of October. And then the indications are the scheme will be varied from August to October, with the indication being that employers will be expected to contribute towards the 8% figure, and that there will be some flexibility for employees to carry out some work. Now, the indications appear to be that the government is envisaging some part-time working during this period. Currently, it's less clear whether employers who still have no work for all of their employees will have to contribute to the employees' costs. I'm certainly seeing some indications in various news outlets with people who sometimes have greater insight into government thinking than perhaps many of us have, that the government is going to be expecting employers to make a contribution of 20 to 30% of the employer's costs of paying for furlough during this period. I mean, the whole aim of the scheme has obviously been to stop employers making immediate redundancies. And some have described furlough as the waiting room for redundancy. And really what we're all now waiting to see is what are the government's intentions from the 1st of August to enable employers starting to plan future workforce requirements. Now, I think the government's aim of this kind of staggered contribution to furlough leave is to possibly spread any job losses that arise over a 3 to 4 month period, rather than several 100,000 employees possibly being made redundant during August, with all the negative headlines that would entail. I mean, of course, the devil's going to be in the detail, which we don't yet have. Is the scheme going to say that for every reduction in the percentage claimable under the furlough scheme, an employer is entitled to ask the employee to carry out that percentage of work for the month. Even with, I mean, there's obviously going to be complications with part-time employees, but even for a full-time employee, the situation is not going to be straightforward. Let's take the most basic situation. A full-time employee is furloughed at full pay, which we will assume is £2,500 per month, with the employer paying the 20% top-up. If the furlough scheme recovery rate drops from 80% to 60%, is the employer going to be able to ask the employee to work for 1 day or 2? A 20% drop would look to be equivalent to 1 day of work for a full-time employee. There are going to be lots of complications around this, and are employees going to be willing to agree to vary their terms and conditions of employment? If they're going to be asked to work part-time, if they're going to be expected to reduce, is the 80% figure going to apply? And there's all kinds of questions that I can anticipate, which I don't yet know the answers to, in terms of what level of contribution employers will need to be made, and in return, what level of work can you require from the employee if they're on furlough, with, I'm assuming that the majority of employers will not be wanting to go for the ultimate stage of requiring the employee to resume work on a full-time basis, because that would mean obviously they would need to start paying the full salary costs. So those are the unanswered questions on furlough. There is likely to be an update from us as soon as we receive whenever the government announces its changes to the scheme from the 1st of August. In theory, we should have expected those changes to be announced this week, but as yet there have been no announcements. And as I indicated slightly earlier, furlough has been described as the waiting room for redundancy for many employers, with employers still not anywhere near back at full capacity in terms of orders, demand for their services. So on that basis, the furlough scheme is simply deferring that employer having to make final decisions on what to do with its workforce. Obviously, everybody keeps using the terminology that we're in unprecedented times, but does unprecedented times mean that normal individual and collective employment rights disappear? Well, the short answer to that question is no. Even though we are in clearly a situation that none of us foresaw even back in February of this year, the reality is that a pandemic, an unforeseen crisis, does not completely cut across employees' rights. If employees are made redundant, they'll still be entitled to redundancy pay calculated based on age, length of service, and the weekly pay obviously capped at £538. They will still be entitled to notice pay being the greater of their contractual notice and or statutory notice of 1 week per year of service, which is ever the greater, and potentially employees are still continuing to accrue holidays through the period of furlough leave. And most importantly, employees will still have the right not to be unfairly dismissed. And I'll touch about some more issues around unfair dismissal. But employers are not going to just be able to say to 20 employees tomorrow or 19 employees tomorrow, we're in this crisis situation, the business is in a real mess. 19 are out of the door tomorrow with no consultation, no fair selection process, and employers won't be able to turn around and say there is an urgent employment situation to this crisis, and that trumped employees' ordinary employee individual employment rights not to be unfairly dismissed. Nor for larger employers does the current crisis waive the obligations to consult collectively, apply with trade or employee representatives. Now, as most of you are probably aware, particularly larger employers, if you are proposing to dismiss 20 or more employees at one establishment in a period of 90 days or less, you must consult with either the recognised trade, if you have a recognised trade union, or with elected employee representatives. And if you don't have elected employee representatives and you don't have a recognised trade union, then you will be required to seek the election of employee representatives. For really large employers who are proposing to make 20 to 99 employees redundant, the minimum consultation period is 30 days before any notice of termination of employment can be given. And were 100 or more employees are to be made redundant in a period of 90 days or less, the minimum consultation period increases to 45 days. Now, one of the key issues, there'll be many employers that are large, but perhaps have more than one office, more than one base. So what is the meaning of an establishment? And that's dealt with in the case of Astor and Another versus Ethel Austin Limited, but more commonly known to employment lawyers as the Woolworths case. And as everybody will recall, a number of years ago, Woolworths went into administration and ceased to operate as a business. And obviously Woolworths had stores of varying sizes all over the country, from small outlets in small market towns to large equivalents to the general retail high stores employing 20 employees. 7,000 employees were made redundant, and collective consultation was not followed by the administrators, and there was a claim for a collective award. And after various appeal cases, the final decision was that the meaning of an establishment is the local employment unit. So if you had a large Woolworths store where 20 more employees were made redundant, then there was a requirement to consult with the recognised trade union before the first of the dismissals takes effect. But where there were smaller employment units, where fewer than 20 employees were made redundant, the collective consultation obligation did not apply, and Woolworths did not have to consult with the appropriate representatives. I mean, there are unanswered questions. What about employees who work in the field or work from home? And I think in those situations that proper legal advice needs to be taken as to the way in which those individuals do work, to see if they are allocated to a particular regional office, regional establishment, or to a business's headquarters, to determine whether or not the collective consultation obligations apply. Now, for businesses that don't have either a recognised trade union or have elected representatives, then there is going to need those businesses to seek the election of employee representatives. And there are guidelines that are issued as to what would constitute a fair and reasonable practice for employers to follow. It simply can't be the case that the employer identifies a couple of management stooges to be the representatives of the employees. It has to be a proper election of employee representatives, with employees having the opportunity to nominate the representatives, and ideally a secret ballot of the employees to enable a proper and independent election of employee representatives. Now, although there are guidelines to follow, it is possible for employers to at least give some kind of steer to their workforce as to how many representatives that they would wish to see elected, and from the areas of the business in which representatives should be elected. Otherwise, employees could be left to their own devices and elect an unmanageable group, say 30 representatives, to be silly. So you can try and give a steer to your workforce as to how many representatives you would like to see come forward. and make some suggestions for the election process. And again, it's probably best once you're getting into that level of detail to take some proper independent legal advice from myself as to how you should go about that process to set up a proper process. But of course, for many employers who do not have representatives, there is a need to build into your timescales if you are proposing to make collective redundancies a 1 to 2 week lead-in period to enable the election of representatives. It isn't something that's going to be able to be turned around quickly within 24 hours. So if you are thinking that you are going to be needing to make large-scale redundancies, then sensibly you need to be building into your timescale at least a week to enable you to have the representatives elected. And the important thing to recognise that consultation does mean with a view to reaching agreement with the appropriate representatives, and that the consultation doesn't start with certain information that's set out within the slide. Prescribed information is given in writing to either the elected representatives or the recognised trade union. And the information has to be given in writing, and the information that has to be given in writing are the employer's reasons for the proposals, and for those employers who are currently in desperate straits at present, then clearly it's going to be a significant shortfall and reduction in demand arising from the COVID-19 pandemic, which means we've got significant losses of income and we need to downsize or right size to meet the size of business. And then what you need to do is to provide to the representatives the number and description of employees who are to be made redundant, and the total number of employees that are employed in each of those groups. For example, we propose to make 5 clerical redundant out of a team of 10. We need to make 15 people redundant on the shop floor out of a workforce of 100. And that's the kind of level of detail that would need to be set out within the letter. You would then need to set out what is the proposed method of selection. So you would need to set out the selection criteria. For example, we would be taking into account absence levels, disciplinary records, length of service, skills and qualifications. And then you would have to set out the method of carrying out the dismissals, so setting out what the process and procedure will be, and then also the method of calculating redundancy pay. The majority of employers, that may be a statement, we will be calculating redundancy pay in accordance with the statutory formula set out in the Employment Rights Act. Some employers may have more generous methods of calculating redundancy pay. Some employers have very generous methods of calculating redundancy pay. I think the really important thing to notice here, if you are proposing to make 20 or more employees redundant from one establishment, that there is a very significant sanction for failing to consult or consult properly, which is up to 90 days pay per employee affected by the proposals. So if, for example, even if you're only making 20 employees redundant, you are looking then potentially of award of up to 1,800 days pay if you times 90 by 20 days pay. So if your employees are on an average of 30,000, you could be looking at a 90,000 award. So potentially there's a very serious financial sanction for not complying with the duty to inform and consult properly. By failing to inform and consult properly, you are increasing the risk of employees' dismissals being found to be unfair because you failed to comply with one of the key requirements of a fair consultation procedure, which is the obligation to consult collectively with either a recognised trade union or elected employee representatives. And the really important thing to note is that really you shouldn't be issuing any notice of termination within the 30-day consultation period unless that's been agreed with your elected representatives that the consultation process has effectively completed. But even if you have a consultation, there are still important individual rights that employees have. So whether or not you have a recognised trade union, there is still a requirement to consult individually with the employee. Even if you've gone through a consultation process with appropriate representatives, you are still going to have to hold individual consultation meetings with individual employees. You're still going to have to write to the individual employee, informing them at risk of redundancy and explaining to them why they are originally selected for redundancy and providing details as to why that individual employee has been selected for redundancy. You're then going to have a consultation process with the employee over 1 to 2 weeks about the individual set of circumstances. So again, if you're dealing with 20 or more redundancies, potentially you could be holding 20 or more individual consultation meetings. Even if you're a smaller employer making fewer redundancies, you're still potentially having to hold a number of consultation meetings with individual employees. And you're still going to have to ensure that the methodology that you use to select those who are made at risk of redundancy, you're utilising fair selection criteria, and the advice that is always expected to be followed by employers but employment tribunals, that you use objective criteria that can be measured. For example, skills and qualification, absence, making sure that you don't follow non-discriminatory criteria, making sure that you take into account why disability can be a fair selection criteria. But what you do need to make sure is that you're not using wholly subjective criteria. There's no realistic way it can be measured or challenged. For example, I've often seen employers use rather vague criteria, for example, flexibility, the ability to work as part of a team, with no real proper guidelines as to how you are measuring that criteria, allowing for wholly subjective viewpoints to be used. So if you are using kind of subjective criteria, then you are certainly much more at risk of your selection process being challenged at an employment tribunal by way of claim for unfair dismissal. And the other thing that you obviously have to ensure is even if you have objective criteria, the criteria have to be applied fairly. So if somebody was scored down for having a disciplinary record when they've only ever been spoken to informally or not at all, then that would be unfair. So you have to make sure the criteria are clear and then followed. And then you have to make sure that you have a proper pool for selection for redundancy. So, for example, if you are considering a group of employees for redundancy, make sure that you have all the with a similar skill set in the pool of selection for redundancy. Now, I do suspect that in the current circumstances, not many employers are going to have alternative roles to which employees can be redeployed, but make sure if you are making redundancies and that you do have vacancies, that you consider employees for alternative employment in the company or associated company. Now, if you fail to comply with the requirements that are set out above, then potentially employees can bring claims to an employment tribunal for unfair dismissal and compensation over and above an individual's entitlement to the statutory redundancy payment, and a notice pay can be compensation for unfair dismissal of up to the lower of a year's salary of the current statutory cap, which is in excess of 80,000. So for the majority of employees, the maximum cap and award would be a year's salary. So that's dealing with redundancies. What I was going to touch upon for the second half of the seminar is the other alternative that many employers will now consider as the furlough scheme comes to an end, is whether as an alternative to making redundancies, they can vary terms and conditions of employment, and to look at the process that employers will need to follow. Now, obviously, redundancies does reduce headcount, and it does achieve a permanent reduction in headcount and a permanent salary costs, but it does come with the permanent loss of those employees, and may mean that employers lose vital skills and experience from within the business, which they may need to retain to enable the business to recover, or that an employer may wish to regain as business builds up. Of course, with redundancies, particularly if there are a number of employees being redundant, there is an immediate impact, because of course those statutory tax is capped at £538 per week. If you have a long-serving employee made redundant, for example, if that employee was age 61, they would have 20 years service to take into account, 1.5 weeks a year of service, and that could be an immediate hit to cash flow of 30 weeks pay paid out after the employee has worked out their notice. And of course, while employees are working at their notice, they're not necessarily going to be as productive as they were. The employees are paid in lieu of notice or put on garden leave. And so there is a potential significant cost in terms of hit to the cash flow through making redundancies, which businesses might want to try and avoid. We think in 3 to 6 months' time, we might have recovered so that we don't actually need to lose all of these jobs. So where do you start as a business if you need to reduce salaries or working hours and salaries? What's your starting point? And there are two starting points. Some contracts of employment may say, for example, we reserve the right to reduce your hours and salary pro rata. There are some contracts of employment that do contain a degree of explicit agreement within the contract of employment that would enable the employer to make some changes either on a temporary or semi-temporary basis. I will say that's probably the exception rather than the rule, but it is always worth checking the contract of employment to see if it permits any flexibility. I think the important thing to realise is to achieve a reduction in the value of an employee's salary or employment package, the degree of consent that needs to be evidenced in the contract of employment is pretty explicit. You wouldn't be able to rely upon a general sort of, we reserve the right to introduce reasonable terms changes in your terms and conditions of employment. But that would not be sufficiently explicit. The other thing that can be agreed, obviously subject to not negating any other statutory obligations, such as statutory holiday entitlement as minimum wage, is that pretty much employers and employees can agree whatever changes in terms and conditions of employment that they want to, providing that both parties agree. So, for example, an employer and employee can agree that for a 3-month, 6-month, or even indefinite basis, there would be a 3-day week or 4-day week, providing that both parties agree. If both parties agree, You just record the agreement in writing, and there is a change in the contract of employment. And regardless of how many people are asked to sign up to that change, there is no problem. Both parties can agree. And so you just move on and everybody carries on working with the modified contract of employment. Inevitably, where the complications arise are when the employee says, I'm not going to agree to that. I want to receive my full salary or work my full hours and receive my full pay. I don't want you to take away my car allowance. Whatever the change that the employer is seeking to ask its employees to agree to. So what happens when the employer refuses, or when the employee refuses to agree to the change? Can you impose that change? Well, the simple answer to that question is no. I know of some employers who have sought to impose changes, and potentially the employer exposes itself to all kinds of potential problems. The most significant problem is that if you impose a fundamental change in the contract of employment and changes in relation to salary and benefits that an employee receives will always be a fundamental change, there is a risk that the employee could resign and claim constructive dismissal. And the fact that we are in an urgent situation with many employers fearing for the future viability of the business does not allow an employer to cut across the contract of employment that it has with employees. So it simply can't impose a change, and if it does, it exposes itself to the risk of a claim of constructive dismissal. The other potentially serious consequence, if, for example, an employer sought to impose a 15 or 20% reduction in pay, employees have an option to say to the employer, I don't accept the change in my terms and conditions that you have imposed. I do not agree to that change. I'm going to carry on working for you under protest. And then the employee could make a claim to the employment tribunal for unlawful deductions from wages. And so while continuing to be employed, the employee could be claiming the shortfall in their salary on an ongoing basis through an unlawful deduction for wages claim. So the whole reduction in salary and benefits that the employer was seeking to agree are lost because they haven't brought to an end the current contractual arrangements by agreement. So what do you do if an employee doesn't agree? Well, the only option that you have is to bring to an end the current contract of employment through a proper process. And so the first stage in that process is that probably you've had some informal meetings or discussions with your employees at present. Obviously, it's made more difficult by the fact that many businesses face-to-face meetings may not be possible, or employees are currently away on furlough leave. Step one would be to write to the employee saying, we've obviously tried to agree the particular changes to your contracts of employment, but you've been unwilling to agree to these. So we need to invite you to attend a meeting to discuss why you're not willing to do these changes, and to set up what I call in the slide a consultation meeting to see if you can address the employee's concerns, and that might involve 1 or 2 meetings with the employee at which you try to seek agreement with the employee or employees as the case may be. And hopefully in the course of that process you may be able to explain to the employer why you are seeking to introduce the changes in terms and conditions of employment, and you may be able to secure agreement. However, if you can't secure agreement, then you give notice of termination of employment to that employee. So you would have to give notice of termination of the employee's employment on their current terms and conditions of employment, which can only take effect after the expiry of the employee's notice period. Now, if you've got employees with long contractual notice periods, typically management staff or sales staff who might have 3 months notice as a matter of course, or with longer serving employees who have an entitlement to notice of 1 week's notice per year of service, then employees are entitled to 12 weeks notice. So you won't necessarily achieve a quick reduction in terms and conditions of employment, because the reduction in terms and conditions of employment will not take effect until expiry of the employee's notice period. And at the end of the employee's notice period, you would normally offer the employee continued employment, but on the amended terms and conditions of the amended terms and conditions of employment that the employee has previously been willing to accept. And the employee in that situation has 2 choices. He either accepts the new employment and continues in the employment of the employer, or he declines to accept the employment and his employment ends. In that latter situation, the employee has been dismissed and has the option of bringing a claim to the employment tribunal for unfair dismissal. The employer can potentially defend that process by showing that it has some other substantial reason for the dismissal, and would try to establish that it needed to make these changes in terms and conditions of employment in order to significantly reduce costs, for example, to avoid the necessity to make compulsory redundancies or to make as many compulsory redundancies as otherwise would be required. And normally, in many situations, particularly in the current set of circumstances, provided the proposed reduction in terms and conditions of employment is within reasonable parameters, the employer would normally expect, if it has followed a fair process, to succeed in a claim, to succeed in defending a claim of unfair dismissal. I should say it is potentially possible for an employee to continue in your employment and bring a claim of unfair dismissal, but the risks of that are significantly lower. So potentially your risk in going down this process is that your decision can be challenged by the individual employee by way of a claim to an employment tribunal for unfair dismissal. I have just flagged that there may be a requirement to consult collectively. Clearly, if you have a recognised trade union, it's probably going to be the equivalent of industrial relations suicide to try and improve changes in terms of conditions of employment without at least first consulting with the trade union. But the important thing to appreciate here is in the Trade Union and Labour Relations Consolidation Act, where we were talking about consulting collectively earlier in this webinar, there is a wider definition of redundancy than would entitle an employee to claim for redundancy. So if, for example, you were proposing to dismiss more than 20 or more than 100 employees to introduce a change in terms and conditions of employment, because those employees were not willing to agree to change, the collective consultation obligations that I highlighted earlier still apply. So in summary, it means if you've got less than 20 employees you were seeking to dismiss at one establishment, then you wouldn't need to worry about collective consultation in terms of the risk of sanction of a protective award. But if you were proposing to deal with 20 or more employees in one establishment, for example, one office, one factory, one workplace, then employees were refusing to accept a change in their terms and conditions of employment, then potentially would need to consult collectively before you could consider issuing notices of termination to those employees. So again, you would have to go through consultation with the information being provided in writing to either the trade union or the elected employee representative. I would anticipate normally we'll be dealing with, for most employers, between 20 to 99 employees. So you would have to go through that process for 30 days before you could issue the first of your notices of termination. So if you actually look at the process that, you know, in terms of possible timelines, you'd have gone through your process of trying to reach agreement on a voluntary basis. You would then be having to consult potentially with representatives who are not yet elected. You might have to call for the election representative. You then have a 30-day consultation period, and then you may have a notice period of up to 12 or 13 weeks. So if employees don't agree, you could potentially have a 4 to 5 month lead-in with where you've got a number of employees refusing to make changes before you were able to achieve the reduction in salary costs or benefit changes that you were seeking to introduce. So again, if you can't reach agreement, you don't necessarily achieve a quick fix. So I think the message of that story is, wherever possible, try and reach agreement. So that may mean that you need to make compromises, but the cost of those compromises may be less than having to go through the process of having to deal with employees who are refusing to make changes. And so, you know, you need to build that into your thinking. Now, typically with these situations, unless you've got organised trade union involvement, you tend to be dealing with relatively few numbers. But of course, if some employees have agreed and then some employees refuse to accept the changes, in theory, the employee who refuses to accept the changes, by the time you've gone through that consultation process, could end up being better off than those that have voluntarily agreed. And you need to work out how you tackle it, because that may not be fair to those employees who readily agreed to the change. So there's practical issues. I mean, it depends, obviously, how fundamental is the change that you're seeking to agree. Obviously, the more draconian the change, the less likely it is that you are going to reach agreement. Are you going to try and seek a permanent or temporary change? Because obviously that can influence how people might react to the change. Do you have to involve a trade union? If so, then it is best to do at an early stage. How many people are you dealing with? Are you dealing with a large workforce where you might have a large number of people who are unwilling to agree to change? And if you're dealing with a unionised employer, how likely is it that you might face the risk of industrial action? And these are all risk factors that you will need to build into your thinking and into your project timelines. So really that is very much a kind of potted summary around the issues that you would need to consider if you were minded to seek a variation in terms and conditions of employment. Clearly, if at all possible, it is best if it's done by agreement, because if it's done by agreement, you will be able to introduce the change more quickly. If it's not reached by agreement, then obviously you need to consider how many refuseniks are you dealing with in terms of the measures that you need to take, in terms of whether you need to be considering collective and individual consultation, or just an individual consultation process and procedure to follow. Now, I've been talking for about 45 minutes, so just by way of summary, we've obviously got the job retention scheme and potentially continuing until October in its current guise until the end of July. The jobs retention subsidy grant may enable some flexibility from the 1st of August, but if you're still in a situation where you don't need your employees, there may be coming in a point where very quickly you need to start planning about how you reduce your workforce costs from the 1st of August, because otherwise you could be having to contribute to the cost of employees if you're not able to achieve any productivity costs from. We may, even after the job retention scheme comes to an end, the depth of the recession that economic commentators are forecasting, and which we're actually seeing now, may dictate that you have ongoing measures in terms of either needing to reduce the overall value of employees' employment packages, or the need to make redundancies beyond the continuation of the furlough scheme. And I think really the message that you need to take away from today is that redundancies and varying terms and conditions of employment take time. So don't leave the changes until the 1st of August or October. You probably need to start planning and taking advice now rather than wait till the job retention scheme comes to an end. And currently, as the scheme currently applies, it is possible, if you know that you're going to have to make redundancies from the 1st of August or later in the year, because you just don't see that business will resume normal levels, potentially you may be able to start the consultation process with your employees now and take advantage of the furlough scheme to subsidise at least some of the notice pay that employees would otherwise be entitled to receive, because they can be given notice while on furlough, as a means of retaining the viability of the business, so that you keep jobs for some of your employees, even if you can't keep everybody's position open. I mean, obviously we're in very significant times. None of us really quite know what's going to happen through the rest of 2020 and 21. Everybody's expecting a fairly significant recession and potentially the need for very significant reductions in productivity, turnover and profitability of businesses. Now, thank you for listening to me today. Hopefully, if any of you require any legal support or assistance, you will contact me. We are fully open, even if meetings have to take place virtually via Zoom, hopefully with a bit more interaction. I am able to ask questions. I think many of you on joining the webinar should have come on muted. So if you do want to ask a question, if you can try and do it, because I don't have sight of you the way we've set this up today, try and do it one at a time. I'm quite happy to take a few questions. If you're going to try and do it, you'll probably need to unmute yourselves. So any questions?
Daniel, I've got a few employees that have worked for me for less than 2 years. So I'm understanding the consultation period wouldn't apply to them. What sort of situation, if I did need to make some of them redundant, what would I have to do? Is there any special rule for them?
With employees who have less than 2 years service, they don't have the right to claim ordinary unfair dismissal. I mean, many employers in your situation might well dispense with consultation, and I have lots of situations where I have advised businesses in these situations, and they've just simply let employees go and made them redundant without following any consultation process. I will say that isn't best practice. There are certain situations in which employers can still be challenged by way of a claim to an employment tribunal. For example, employees can challenge their selection possibly through the discrimination legislation. For example, if you have somebody who's away on maternity leave redundant without following a first selection process, even though that employee has less than 2 years service. They might say, you took into account my pregnancy, that's unlawful pregnancy, sex discrimination. For example, employees may have been asked to accept a reduction in salary, refused to do it, the employers imposed a reduction in salary, and the employees asserted a right not to have an unlawful deduction from wages made, and they could say, you're making me redundant because I've asserted a statutory right. So there are some limited exceptions. I would always say you can follow some form of process, even if an employee has less than 2 years service, because there is always the possibility that some kind of employment claim may be brought. And if you have followed a process, then you are in a better circumstance to deal with those types of claim. Although, as I say, many employers don't always follow best practice when they're dealing with employees with less than 2 years service.
Okay, thank you. That's very helpful.
Do we have any other questions?
Hi Daniel, it's Helen. I just wondered if we're able to sort of impose some restrictions or guidelines on holiday. So when we could, say to employees they have to take a certain number by a certain time.
Obviously, under the current circumstances, the government has allowed some flexibility in terms of allowing the carryover of holidays, because it's obviously going to be so difficult for employees to take holidays in the current situation. Some employees could have been on furlough leave, the holiday leave is still accruing. It really depends on the contract of employment. If some contracts of employment do allow employers to dictate when holidays are taken. So if you're trying to get employees to take their holidays in a period when it's less busy, for example, at Christmas time, you could possibly give notice to your employees. You do have a right under the working time regulations to give notice of employees to take holiday. Equally, you could possibly try to deal with it. It may not suit you to allow employees to take their holidays if demand builds back up. So there are certain mechanisms that are possible, but it's best to try and deal with those situations by reference to the contract of employment. But there are certain rights within the working time regulations dealing with if you want your employees to take holidays, to give them notice of when you're expecting them to take it. Does that answer the question, Helen?
Yeah, I think so. Thank you.
Any more questions? There's a big silence. Oh, one thing I should have mentioned, and apologies for not mentioning it, is if you are making collective redundancies, there is also a duty to notify the Secretary of State at the Department of Business, Enterprise and Regulatory Reform, and it's actually technically a minor criminal offence not to do so. Any other questions before we bring an end to the this webinar?
No, thank you very much. It's been really helpful.
Any others? Okay, thank you everybody for joining us today. If anybody's got needs to take any individual advice, please don't hesitate to contact me. Thank you.
Thank you.
Thanks. Bye.